Good day. Welcome back to Constitutional Studies and Week 5. This week, we will deal with the topic of fundamental rights. It's a topic that those of you who've seen the course outline will realize stretches across the next 3 to 4 weeks. And today, we will begin an introduction and a broad summary of that topic. So let me begin by conducting a quick overview of the course so far. So if you've made it all the way into week 5, you know that in the last 4 weeks, we have taken up discrete questions in constitutional law and constitutional studies. Like in week 1, we asked, why have a constitution at all? Especially when we already have an electoral democracy, do we need a constitution? If so, what is the relationship between ideas of a democracy and a constitution? In week 2, we answered that question, said, okay, we must have a constitution, but we then asked, how should we make a constitution? And who should make that constitution? We noticed that in India, we chose a specially representative assembly to make a constitution. It was lay people who were elected for the most part, but it was uniquely representative of the people of India. In week 3, we begin our reading of the Constitution, and we begin where most people might start at the opening stanzas, which happen to be the preamble to the Constitution. We asked specifically, what is the role of a preamble in a Constitution? Do you need a preamble? And if so, is it just a preface or an introduction? Or is it something of a manifesto? And then we asked, after reading the preamble, how should we interpret it? And how should we enforce it, if at all? In week 4, we moved on to the next significant question while interpreting the Constitution, which is to ask, who are citizens of the country? Who belongs in this constitutional framework? And how should we recognize their citizenship? So last week, we spent some time going over principles of jus soli and jus sanguinis to examine how citizenship could be conferred in a modern state. We asked whether all residents in a country are automatically citizens. If not, what other special connection must we ask residents to show before citizenship is assured? We then went on to examine in some detail what the Indian Constitution and the relevant statute, in this case the Citizenship Act 1955, tells us about citizenship. We understand that the Constitution and legal framework adopt all models of citizenship. Some birth citizenship, some jus soli kind of citizenship, some descent-based citizenship, jus sanguini type citizenship, and some voluntary citizenship by registration and by naturalization. So all models of citizenship find a place in the Citizenship Act, and the question that we have to ask is, what model of citizenship are we moving towards? For that, we need to understand the challenges, the controversies around citizenship in India, and we asked pointedly whether we could adopt a model of citizenship in the Constitution that speaks both to the concerns of Indian expatriates living in West Asia or the United States or Europe and Australia and other parts of Asia, as well as those who are immigrants into India. Is there a single model of citizenship that we can offer both these constituencies that would be grounded on common principles and be morally defensible? That is the challenge we set ourselves, and we tried to show that in a globalized world, we might want to adopt models of citizenship that primarily rested on voluntary commitments to being part of a citizen of a political nation. And that model of citizenship would accommodate the large movement of people across national and political boundaries. So that was week 4. We now will move in week 5 to open up a very, very important topic, and that is the topic of fundamental rights. This is a topic that we will stay with for the next 4 to 5 and 6 weeks and deal with several case studies and several controversies that arise on both an understanding and an interpretation of citizenship. We will get to that, but let me just in this week, in week 5, give you a broad outline of how we might think about fundamental rights. What are these fundamental rights? I ask in lecture 1. What does it mean to have a right? Now, in a law school, we will spend much time trying to analyze the legal technical aspects of what it means to have a right. For this lecture, I will just try to present this rather complex area in a simpler form. We must understand that the political rights that we have in the Constitution are not accidental. They have emerged, much like debates around citizenship and the preamble, out of an almost 100-year political churning, the freedom movement. And we want to understand when particular rights emerged and how we should appreciate their historical significance. So both of these things I will do in lecture 1. In lecture 2, I will present the broad outlines of the fundamental rights in the Constitution and identify the key different types of rights that we have in the Constitution, and conclude in lecture 2, which will by far be a shorter lecture, with a broad outline of the legal and political enforcement of rights. It's all right to have some constitutional fundamental rights. How do we anticipate that these legal fundamental rights will be enforced? That is the topic of lecture 2. So let's get started with lecture 1. In the first part of this lecture, I will focus on a very broad question. What do we mean by rights? What does it mean to have a right? What is a right? A right to what, or is a right in somebody? I will then present a broad typology of rights. What are the different types of rights we have? In common language and discourse, we use the language of rights all the time. We might use them in a family. We might use them in the workplace. What kinds of rights? Are they the same rights in the family and the workplace and in constitutional law? Or are they different kinds of rights? I will present a very brief introduction to the core international human rights. Often we come to think of international human rights as some kinds of fictional claims not to be taken seriously. And I want to present a very broad outline of how these international human rights came to be and why they continue to inspire and motivate political action across the world today. I'll close with a broad outline of constitutional fundamental rights and paying attention to both terms, what is constitutional and what is fundamental about those rights. Let's begin with a broad understanding of what it means to have a right. When we use the term right in common language, we use that all the time in casual conversations, when we get caught up in heated argument, and in structured contexts like the workplace or the university. Students use rights claims all the time. What kind of rights? What do they mean when they say they have a right? So let's unpack at least a few different senses in which the term right might be used. First, to have a right may mean the right to do something. For example, you might say, I have the right to speak or the right to express myself. This kind of a right to do something, is commonly understood as a privilege or a liberty. When I say I have the right to speak, I often mean that you don't have the right to stop me. So this kind of right, the right to do something, is one rather large species of rights claims that we commonly use in our everyday language. The second sense in which we might use a right is to say that I have a right, meaning that someone else has to do things for me. This kind of right is a right that imposes obligations on others. It allows me to make claims of others. For example, I might say that I have the right to be treated equally. When we ask, what does that mean? What does it mean? What does it mean to say that you have the right to be treated equally? The sense that we would give to that rights claim is to say that you have the obligation. Those to whom my right applies have the obligation to treat me equally with others. So this is a very different sense from the first sense in which we use rights as a privilege or a liberty. The third sense in which we might say that I have a right is to have a right to do something that changes another person's legal position. This kind of right, the power to change someone else's legal position, is often a civil right. It's not a constitutional fundamental right. Now, let me just use a simple example. I have a contract, for example, to buy a car. If I enter into such a contract with a potential seller of a car, by closing that contract, I have the right to have the other person hand over the car to me. I have changed their legal position as the owner of the car, and I become the owner of the car. I'm using a very simple example. There could be far more complicated examples of the right to change another's, the capacity of a rights holder to change another person's legal position. The fourth way in which we use rights claims is often to say that by saying that I have a right, I'm free from a liability or a legal duty to someone. For example, a right to remain silent in a criminal investigation. When I have a right to remain silent, no matter what legal powers and authority a criminal investigator might exercise, my right to remain silent gives me an immunity to whatever statutory or legal power the criminal investigator is using. It's a sort of a right is in an immunity sense is like a bubble. It's a bubble that prevents the interference of others with my right. So whenever we use the word right, we might be using it in any one of these four senses discussed here. We might be using it in other senses as well, but for now, let's just work with these four senses of a right. The next question that we need to unpack is to understand the form and function of rights is what is the effect on the person who claims a right? As the slide suggests, what do rights do for the persons who have rights? Oftentimes, whenever one says that you have a right, it means that the person has autonomy, the will or the choice to do something or not to do something. So it empowers the rights holder to either do or not do something. The second important element to having a right is that it elevates some of the rights holder's interests, for example, education and healthcare, and places it above the common fray. This ability, what rights in this sense is a power shifting device. It takes my will, my choices, my interests, and elevates it, these individual choices or interests, and elevates them above the ordinary social interests that might otherwise override them. You might say, for example, that I have the right to sit in the middle of the road, but we understand that the presence of rules and regulations on the use of the road that serves the common interests of the community might ordinarily override your rights. So we had discussed very briefly in the last session no, I the elevation of individual choices of interest is visible in a case like the case decided last week by the Indian Supreme Court on the question of whether people may choose to protest in the middle of the road. You notice that the court circumscribed the rights of the protesters to the use of the public road. If the court had held that protesters, anyone who wanted to raise their voice and protest, have the right to occupy the road, then the common public interest in the use of the road would give way to the protected right in this case. So, this is the effect, the power shifting effect of having a right. Let's use another example to better understand this. And in this case, let's talk about food. Ordinarily, any person has the right to procure or forage for food to satisfy their hunger. We might say of any person, any human being, you can either procure using whatever market facilities you have access to, or find your food. So yes, you can satisfy your hunger in this way. But when we say that the person has a right to food, what has changed? The right to food has in effect imposed an obligation on society or maybe the state to ensure that no person is left hungry. So notice the effect of the right. The presence of a right imposes obligations on other actors, whether the society or the state, to ensure that no one is left hungry. This kind of power shifting effect is what rights have. And rights, the form and function of rights is to shift power, the power balance between the rights holder on the one hand and society at large. This is the effect that rights have. And as we explore this question in greater detail in the Constitution, we will come to understand this function in a more significant way. What are the various kinds of rights that we have? And mind you, I'm yet to talk about constitutional rights so far. We're just talking about rights more generally. The first broad typology of rights that we must become familiar with is the distinction between natural rights on the one hand and legal rights on the other. Natural rights, when we use the language of rights in everyday language, we may not clarify. Am I talking about a natural right? Am I talking about a legal right? Am I talking about a human right? Am I talking about a constitutional right? I may never ever say what right am I talking about in ordinary language. But we might want to then further specify rights so that we have an understanding of the specific types of rights and what obligations they give rise to. So let's begin with natural rights. Natural rights are seen to be grounded in the moral power, the dignity, and the capacity inherent in every human being. Notice that the person is the foundation of natural rights. It's rare that we give such rights claims or we believe that rights are inherent in animals. There is something specific to the nature of the human species to which we attach rights claims. So whenever we say that someone has a natural right, that natural right emerges from them being human. What kinds of natural rights could we have? We normally speak in the language of the basic entitlements to life, liberty, and property. These are the natural rights that have been spoken about in the intellectual traditions of talking about rights for centuries. Why life, liberty, and property? Because we see these three elements as being inherent and emerging from the dignity of human beings themselves. Where do natural rights come from? And there is much controversy and intellectual debate about whether we have natural rights at all, and if so, where do they come from? And let me just identify, for the purposes of this lecture, two broad traditions of thinking about natural rights. We may think about natural rights as being God-given and emerging from, literally the heavens, or we might see rights as emerging from the human condition, right? From the nature of the human species and human morality, a natural human morality. Now, this might be an unsatisfactory explanation. One might expect a greater specification of the sources of natural rights, but for the moment, let's stop here. For a course like this broad introduction would suffice. In the body of natural rights, we broadly have moved towards claims about human rights. Now you might ask, are human rights natural rights, or are human rights what is on the other side of the column, legal rights? And the answer is that some human rights are moral rights and seen as moral rights or natural rights, while some human rights are seen as legal rights. But that body of human rights are usually quite wide. They have both negative and positive rights, sometimes requiring states to do affirmative acts, while at other times requiring states to carry out some to prevent interference in our personal lives. Often, when we speak about human rights, we speak in terms of them being universal to all human beings, not contingent on the nation state that we live in or the particular political constitution under which we live. We also see human rights as being inalienable. Nobody can take away your human rights. And as being fundamental, overriding all other rights, all other legal and political rights that you might claim, and binding on all actors. This language of human rights is very important to understand and appreciate, and I sense that many of us grew up being exposed to the language of human rights, but not being able to precisely locate what human rights might mean. So, I began with natural rights. I then briefly introduced the idea of human rights. I now want to get onto the legal side. And we recognize that legal rights are created by the law in various ways, enforced by statutory law, and we call them positive rights. By positive here, we don't mean that they only impose obligations on the state. What we really mean is they're positive rights in that they are enforced and created by the state. So legal rights are created by the state, but they can also be erased by the state. So legislation can take away legal rights. So no matter what the legislation is, we may continue to insist that we have human rights contrary to legislation. We may also continue to insist that we have natural rights contrary to legislation. But legal rights are always focused on the question, what has the state created in this case? The fourth category of rights, with which I conclude my typology of rights, is to explore what it means to call something a constitutional. Constitutional rights are qualitatively different from and superior to legal rights. So let's assume for a moment we discussed some legal rights emerging from the Citizenship Act of 1955. These legal rights are created by Parliament and applicable to all those resident in India, citizens or not, or those who seek to become citizens of India. Constitutional rights are superior to legal rights in this important way. If any legal statute or decision of an administrative body, or sometimes even of a court, violates constitutional rights, then those decisions can be declared invalid. So constitutional rights sit above the ordinary legal rights, natural rights, and human rights of others. They are specially protected by the Constitution. But when we say they enjoy constitutional protection, it doesn't mean that they are immutable. It doesn't mean that they can never be changed. It only means that they can be changed by amending the Constitution, which is far more difficult than just changing a statute. So let me bring this together before we move away from the typology of rights. We have discussed 4 kinds of rights. So every time we use rights language in a common sense, in common conversation, we would do well to ask the question, what right are you claiming? Are you claiming natural rights, human rights, legal rights, or constitutional rights? By bringing this kind of clarity to our everyday conversation, we make considerable progress in understanding the nature of constitutional fundamental rights. I said that I would briefly introduce the Universal Declaration of Human Rights and the language and the tenor of international human rights. The Universal Declaration of Human Rights, which was created in 1948 by the several nations that came together, and we're talking about 150 nations plus, came together to create the Universal Declaration of Human Rights, an international covenant. What kinds of rights does it have? Notice how the Universal Declaration of Human Rights begins. It begins with the broad proposition that all human beings are born free and equal in dignity and rights. Notice the emphasis on human beings being born with dignity and rights. And this is not conferred by states or conferred by God, but natural in its origin, just by virtue of our birth. It continues to assure us that everyone is entitled to all the rights and freedoms set forth in this declaration without distinction, meaning without discrimination. So all human beings without discrimination. What rights do we have? We have the common rights of life, liberty, and security of person. What we discussed when we spoke about natural rights, these are declared as core human rights. But further, that everyone, as a member of a society, has a right to social security and rights to economic, social, and cultural rights, which are indispensable to one's dignity and development of one's personality. This kind of language, the kind of language that you find in the Universal Declaration of Human Rights, brings together different kinds of rights. They are all human rights, but they are rights that are sometimes about civil and political goals, and at other times about economic, social, and cultural goals. As we all know, 2 different treaties, international treaties, came to be signed, called the International Covenant on Civil and Political Rights in 1976, and the International Covenant on Economic, Social, and Cultural Rights in 1976, that build on the Universal Declaration of Human Rights. So these rights, put together, comprise a corpus of international human rights that operate as a broad framework to guide rights thinking across the globe. These rights are not dependent on your constitutional guarantees. They go beyond them. And we may always take reference to these international covenants and the Universal Declaration when we are trying to evaluate and assess what human rights we have. Often, while talking about international human rights, we talk about 3 kinds of rights, or 3 generations of international human rights. And let me just refer to them When we speak in the language of generations, we think of this in terms of a chronology. But we needn't do that. We can think of these mainly as three different types of rights. The three broad types of rights are civil and political rights, economic, social, and cultural rights, and collective rights or group rights or solidarity rights. Paying attention to these types of rights is very useful when we begin our discussion of the Indian Constitution. In the Indian Constitution, rights and directive principles, Part 3 and Part 4 of the Constitution, make up the corpus of human or natural rights that are crystallized into constitutional rights in the Constitution. In the Indian Constitution, a decision was made to put political and civil rights broadly into Part 3 of the Constitution and call them fundamental rights, and to put socio-economic and some cultural rights broadly in Part 4 of the Constitution and devise a different mechanism for their interpretation and enforcement. There are other constitutional rights which are not in Part 3 or in Part 4, and these might, and we have identified some of them on the slide for you. Articles 265, which deals with crystallizes the broad principle that there can be no taxation without representation. Article 300A, which now contains the remnants of a right to property, and something that we discussed earlier in this course, the right to vote, which is in Article 326. You can see in the 4 columns on your slide a broad presentation of the categories of rights. Civil and political rights, which include the rights to equality and non-discrimination, as well as the liberty rights to speech, association, and movement, and protections against criminal prosecution by the state, as well as the core fundamental right to life and personal liberty. On the social and economic rights, and I think by this point in this course, you would do well to equip yourself with a small pocket book of the Constitution so that you can constantly reference the bare text of the Constitution, something that all of us as educated citizens should have access to and should be able to read and understand. The social and economic rights are spread between Part 3 of the Constitution and Part 4 of the Constitution. Some of them, such as the right to access public spaces without discrimination, are broadly set out and impose obligations on various state and non-state actors, as does the abolition of untouchability. We have very broad directive principles of state policy in Part 4 of the Constitution, which deal with the structure of the economy, the nature of protection of labor, the protection of women and children. Cultural rights are once again distributed between Part 3 and Part 4 of the Constitution, but broadly we have some specific rights that we grant to the protection of language and culture, as well as a right to education. We also protect some religious rights with respect to the ability to establish and administer educational institutions, as well as to manage religious affairs. So the constitutional fundamental rights cover the constitutional rights and principles cover a very large swathe of our collective lives. And when we read Part 3 and Part 4 together, we understand that the Constitution places these values to be fundamental in the way our society evolves and is governed. Why do we call Part 3 rights fundamental is an important question. Not only are they constitutional rights, they're constitutional fundamental rights. And let's make two or three broad legal points that might be useful for all of you as we go off into the case studies in future weeks. The first point is that Article 13 of the Constitution makes it clear that if anyone makes any law against the Constitution which takes away or abridges any of the fundamental rights in Part 3 of the Constitution, then that law is invalid or becomes void. Now, what does voidness mean? It's a legal term, it's a term of legal art, but broadly, let's assume for the moment that voidness means will have no legal effect. So Article 13 is a very powerful article because it instructs all those who take and exercise legal public authority that if such public authority is exercised in a manner that offends rights, it would be invalid, have no legal effect. Who do these fundamental rights apply to? Broadly, Article 12 tells us that these fundamental rights apply to legislatures, the executive branch of government, as well as other authorities. This would include local authorities and some might argue even the court. So fundamental constitutional rights are primarily protected against state action, against the public authorities acting in a way that infringes rights, not against private actors and private associations. So, okay, the state cannot violate my rights. Who's going to enforce all of this? Who's going to ensure that indeed the state follows this requirement? That is taken care of by Article 32, which gives the Supreme Court, and Article 226, as we will see later, gives the High Courts the power to enforce these rights and to declare that state action is invalid. So the courts form a very important part of ensuring the protection of fundamental constitutional rights. Now let's put the three articles together. 13 tells all actors, state actors, that they cannot make any law that abridges or takes away fundamental rights. 12 clarifies that this is primarily applicable to state actors, meaning the legislature, the executive, and other local authorities and the judiciary, other public authorities. Finally, Article 32 gives the power to the Supreme Court to enforce these rights. Taken together, fundamental constitutional rights receive a very strong protection. So let me stop here with lecture 1. We're just south of 40 minutes. I will come back to part 2 in lecture 2 for week